Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Coming to you from Washington's premier indoor shooting facility. Of course, that's Security Gun Club right here in Woodinville, Washington. Now, listen, I know I'm a little late to the party, but sometimes that gives me an opportunity to digest the big ruling a little bit more and be a little bit more thorough in the analysis and connect a few dots for you. As we know, earlier this week, we had a huge ruling out of the Fourth Circuit. It deals with Maryland's license to own a firearm scheme. You know, the background check that you have to go through before you can go through a background check. And the Fourth Circuit three-judge panel has found no bueno on that statute and has struck it down. So this actually probably has a much larger implication than you may think, far beyond the state of Maryland. So today, let's geek out for a few minutes and let's talk about, is this the beginning of the end for pre-purchasing licensing? Okay, so the case we're talking about today from the Fourth Circuit is Maryland shall issue Inc. v. Moore. This was a challenge filed many years ago, actually, to Maryland's license to own a firearm scheme. As we know, some states, Illinois, you better be listening here, actually require their residents to secure a license, that is a permission slip from the government, before they can then go to a gun store and purchase a firearm, or what we like to call an inalienable right. In other words, they actually have to go through a background check before they are allowed to go through a background check. Now, Maryland is not alone in this insanity, but Maryland is the first state that we're going to now see this law struck down. Now, this suit was actually brought way back in 2016. That's how long the folks in Maryland have been subjected to this insanity. And on two separate occasions, the district court actually upheld the law. One time saying that, well, you know what, they don't even have standing here. Don't know how they came to that ruling. The second time they ruled that, in fact, it didn't violate the Second Amendment, that the activity that was covered here was not protected by the Second Amendment. Why is that? Because it didn't have anything to do with keeping and bearing a firearm. No, it had everything to do with acquiring a firearm. Sound familiar? Because we're going to talk about that. Now, the court basically summed up their ruling this way. Plaintiffs seek to enjoin the state from enforcing only this additional preliminary handgun licensure requirement, and plaintiffs' challenge must succeed. The challenge law restricts the ability of law-abiding adult citizens to possess handguns, and the state has not presented a historical analog that justifies its restriction. Indeed, it has seemingly admitted that it couldn't find one. Under the Supreme Court's new burden-shifting test for these claims, Maryland's law thus fails, and we must enjoin its enforcement, so we reverse the district court's contrary decision. Now, as I mentioned, this case was brought back in 2016, and after multiple unsuccessful attempts at this appeal. Why? Well, because the rules of engagement were different. They were getting shot down on intermediate scrutiny. However, post-Bruin, this case was revived, and the court has now ruled Maryland's law fails the new Bruin test. As we will explain, plaintiffs have shown that Maryland's handgun licensure law regulates a course of conduct protected by the Second Amendment, and Maryland has not established that the law is consistent with our nation's historical tradition. Remember, I also mentioned that one of the ways that they had previously lost was that there had been a ruling that the Second Amendment did not protect this type of activity because it had nothing to do with keeping and bearing an arm. It only had to do with how a person acquires or comes into possession of a firearm. Now, for those of you who geeked out on this video right here, you will recall the case of Rocky Mountain Gun Owners v. Polis, where a very old judge has ruled exactly the same way. The Fourth Circuit, however, has chucked that argument out on its ass and shot it down in the following manner. Yet there are a few wrinkles to iron out. To start, you might note that the amendment's text protects only the right to keep and bear arms. But on its face, the challenge law says nothing about whether plaintiffs may keep or bear handguns. It only restricts plaintiffs' ability to purchase, rent, or receive them. How then does the law regulate the right to keep and bear arms? The answer is not complicated. If you do not already own a handgun, then the only way to keep or bear one is to get one, either through sale, rental, or gift. And the challenge law cuts off all three avenues, at least for those who do not comply with its terms. The most common comment that I get anywhere in the comment sections down below is just "shall not infringe" with about 4 exclamation points behind it. The second one I get is "a right delayed is a right denied." And I absolutely positively agree with that. And you know what? So does the 3-judge panel in the Fourth Circuit, because in shooting this law down, they specifically found, but even though Maryland's law does not prohibit plaintiffs from owning handguns at some time in the future, it still prohibits them from owning handguns now. In order to get a handgun, plaintiffs still have to follow all of the law's steps, and although they will be able to complete each one, it is impossible to do so right away. Plaintiffs can't receive a license to legally acquire a handgun until the state reviews their application, which can take up to 30 days. So no matter what plaintiffs do, there will be a period of up to 30 days where their ability to get a handgun is completely out of their control. In other words, though it does not permanently bar plaintiffs from owning handguns, the challenge law deprives them of that ability until their application is approved, no matter what they do. And I want you to think about that not only on all of these ridiculous pre-purchasing licensing requirements, which was also just shot down yesterday in Oregon under ballot measure 114. But what about statutory waiting periods? Many states have statutory waiting periods for which there is no historical tradition of having. And this reasoning right here is the exact reason why all statutory mandatory waiting periods are probably unconstitutional. Now, clearly believing that this conduct falls under the protection of the Second Amendment, of course, the burden then shifts to the state of Maryland to come up with some type of a historical analog to justify this law's existence. Now, I have seen some very paltry attempts at trying to come up with some sort of a historical analog. The state of Maryland, however, has probably failed about as miserably as any other state defendant I have seen so far. The court has specifically found, but the 2 historical examples that Maryland cites are not relevantly similar to the challenge law, and it has offered no other historical evidence to justify its law. Indeed, Maryland admitted at oral argument that it had not presented a proper historical analog for the challenge law, noting that it had identified no founding era laws that required advance permission before a citizen could purchase a firearm. And I want everyone to focus on that exact last sentence there, because that is the exact argument for any of these pre-purchasing licensing requirements. Nobody needs the government's permission to exercise their First Amendment right. Nobody needs the government's permission to exercise your Fourth Amendment right, your Fifth Amendment right, your Sixth Amendment right, your Eighth Amendment right. But in some states, God forbid you want to exercise your Second Amendment right, well, no, you need government's permission first. The court went on, further criticizing Maryland as follows. Maryland's historical evidence is scant at best. It first asserts that its law is justified by the historical limitations on the ability of dangerous people to own firearms. But Maryland points to no historical laws for support. Instead, it cites various provisions of modern U.S. code that prohibit certain categories of people, including felons, those addicted to controlled substance, and those convicted of domestic violence misdemeanor from owning firearms. So think about it. The state admits in oral arguments they don't have any historical traditions, and then they cite to laws that are completely apples to oranges and modern firearms regulations. It's no wonder that they were so soundly beaten in this opinion. Now, they continued down this road of, well, you know what, these people may be dangerous, and therefore we have the right to keep them disarmed at the current time. The court drew that distinction as follows, however. The modern federal laws that Maryland has cited and the historical laws allegedly supporting a tradition of prohibiting dangerous people from owning firearms all acted through one mechanism: punishing certain classes of supposedly dangerous people if they don't give up their arms or prove that they are not dangerous. But that is a different mechanism than making every person seek the government's permission before they can even acquire arms, preemptively disarming every person until they can each prove that they are not dangerous burdens a far broader swath of people. And then ultimately, the court came to this conclusion. In Maryland, if you are a law-abiding person who wants a handgun, you must wait up to 30 days for the state to give you its blessing. Until then, there is nothing you can do. The issue is out of your control. Maryland has not shown that this regime is consistent with our nation's historical tradition of firearm regulation. There might well be a tradition of prohibiting dangerous people from owning firearms, but under the Second Amendment, mechanism matters. And Maryland has not pointed to any historical laws that operated by preemptively depriving all citizens of firearms to keep them out of dangerous hands. Plaintiff's challenge thus must succeed, and the district court's contrary decision must be reversed. Now, that was signed by 2 of the 3 justices in a 21-page opinion. There was a dissenting opinion. I haven't had the chance really to go through it. I'm sure it will be rather entertaining. I think that this is a huge win and the beginning of the end, though, for all of these pre-purchasing licensing requirements. Because if you talk to any of your friends who may favor civilian disarmament, ask them, do any of them need a license before they pick which church they're going to go to? Do any of them need a license before they decide to speak freely? Do any of them need a license before they vote? Probably should, but do they? No. Do any of them need a license before they're free from unreasonable government searches and seizures? Or do they need a license before they're not forced to compel evidence against themselves? Of course not. So then why is it that only the Second Amendment in the Bill of Rights is required by some states to get their blessing before you can actually then exercise what is supposed to be an inalienable right? Listen, I'm sure that the state of Maryland is completely crapping their pants today. There likely will be an appeal to a full en banc panel of the Fourth Circuit, so this is a long way from over. The case, once again, is Maryland shall issue Inc. v. Moore. We will link it all up down below so you can geek out on the opinion for yourself. In the meantime, if you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. If you don't, that's okay. That information is also down there in the description box. Now, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.